The idea of completing the due diligence is to ensure that they're managing and operating the property in an acceptable manner, whereas you won't have to deal with major increases in maintenance or common charges. You won't have to deal with large amounts of capital assessments or special assessments. Already familiar with how they've been managing and operating the property, and based off of that, you know that they have a good amount of funds in their accounts. Based off of their history, you do your best to try to predict what may or may not happen in the future.
Welcome back to Real Estate Investing in New York with me, Christina. And in this episode, we are discussing the pitfalls of improper due diligence. So stay tuned, we're covering everything here. This is Real Estate Investing in New York with Christina, helping you achieve a future of financial success by making intelligent real estate investment decisions today. Welcome back, guys. Thank you for being here. I have a guest on the show with me today, a phenomenal real estate attorney. His name is Jonathan Movtady.
Thank you for the kind introduction, and thank you for having me.
Welcome, Jonathan. The name of your company for anybody who wants to find you?
Movtady Law Office.
Perfect. Thank you. And welcome. I appreciate your time here.
My pleasure.
If you're watching on YouTube, you can see Johnny, but for those that are only listening, I think that it's worth mentioning that you always have the coolest look. You show up in your all black uniform. I've never seen you wearing anything other than this. Black hat, black blazer, black t-shirt, black pants, and very sleek. I love it.
Thank you.
And when it comes to working together, you are just as cool, very approachable. We're on a text messaging basis. I can call you, text you, message you anytime. You spend as much time as we need. And that's very unique for an attorney to have. So just another one of the many reasons why you are the person that we have on this show and not just any other attorney. This is such a loaded topic, and a lot of people are not necessarily knowing exactly how to proceed when it comes to the due diligence phase of their purchase. So we look at apartments, that's step one. We place offers, that's step two. Negotiate, finally decide that we have a meeting of the minds, and now due diligence begins, right? So due diligence is done before the purchaser signs their contract. It is a way that we are able to analyze the building and determine if this is a good decision, if the purchaser really wants to buy here. And we lean very heavily here in New York on real estate attorneys that have expertise in New York City and New York State condo and co-op buildings, is what I'm trying to say. In Manhattan and Brooklyn and Queens and the boroughs of New York City, the inventory is very specific. You're working with buildings that have to be analyzed in a certain way, or you can really get burned, right? And we have examples of how this can happen. And very often our clients want to use family recommendations, let's say, with the greatest of intentions, right? You want to use someone that you trust. So you maybe trust a referral from a family or friend who may have purchased outside the city, and you use maybe a family referral or a friend referral, or you do your own research, and maybe you're comparing based on price, right? People are very price conscious nowadays, and they might want to cut a corner with respect to the real estate attorney that they're hiring. You will find very affordable real estate attorneys, but what you will also notice is that they're not doing the due diligence that is required to properly analyze a building in New York. So this is why I'm introducing Jonathan to our listeners. Jonathan is an expert real estate attorney with specialization in New York City condo and co-op buildings. Absolutely critical. And the scariest thing is that if you are not using an attorney that has this expertise, you don't know what you're missing. You just will not know what you're missing until you encounter a problem later that could have been prevented by doing the right due diligence. Of course, God willing, you never run into problems, even if you skip proper due diligence, but it's very important, and I cannot emphasize it enough, and I emphasize it to my clients. So here we are, Johnny. Thank you. So The first thing I would love to talk about are what are the basic documents that you are requesting and that you analyze when we begin the due diligence process?
Okay, happy to answer these questions, but before I do, I just wanted to expand on what you had mentioned. There are a lot of attorneys and law offices who practice a few different fields, whereas my practice is specifically focused on residential real estate transactions, and most of that tends to be condos or co-ops in New York City. So the other attorneys, like a family friend or maybe a divorce attorney or an estate attorney who is happy to help their client with a residential transaction, they don't have the same experience that I do because this is my primary focus. So as far as the due diligence review goes, the idea is to try to get as much information on the property to assess whether or not it's a good investment or a good idea for the client to make a purchase, because most of the time these real estate purchases are the largest investments that they're going to make, and there's a lot of thought and a lot of consequences to whether or not they make that investment. So what I do is I provide as much information through my due diligence review as possible so that they can make a fully informed and educated business decision, which at the end of the day, that's what it really is. And part of the due diligence review is going over everything pertaining to the property. And that includes the offering plan, the amendments, the house rules, the bylaws, the financials, the budget, minutes from the board meetings, as much information as we can gather to understand how they're managing and operating the property and if it's in an acceptable manner. And we're looking for any red flags, any cause for concern that could potentially affect the purchasers at some point in the future. So every piece of information that's gathered is a piece of a puzzle. So if you miss one piece, it might not be detrimental, but you do want to try to get as much information as possible to get a complete picture of what's going on at the property.
So the key documents that we need to look at that are most critical are building financials, right? We look at the reserve fund, things like that. We look at the offering plan. We look at meeting minutes. That is extremely important. And the questionnaire that goes to management, just as like an overall, if someone was to outline the episode for themselves to know what's coming. And then I think we should dive deeply into each of those items. Let's start with financials.
Okay. Typically with the financials, they don't have the latest or the financials from that year. So for example, right now we're in April of 2025 and most buildings don't even have the audited financials from 2024 yet.
Right.
So chances are you're going to be looking at financials from at least a year ago up to 2 years ago. So that's why I'd mentioned that it's a puzzle and every little piece of the puzzle helps you understand the big picture. So in addition to the financials, you also want to try to look at the budget. And the budget, hopefully they have it available for that year, and that'll help you understand their projections on where their expenses are and where their income is coming from. And hopefully the income will be exceeding the expenses so that they're operating with positive cash flow as opposed to having a deficit. In addition to those, the financial statements and the budget, you can also look through the meeting minutes and get a better understanding of what's being discussed at those board meetings, and in particular, how they're handling the financials, what their projections are, whether or not they anticipate needing an increase in the maintenance or the common charges, whether or not they need a special assessment. You could also potentially find updates on what the balances are in their cash and reserves accounts. But one of the best ways to get as much information as possible is through the due diligence questionnaire, because within that questionnaire, you can ask a lot of specific questions that will help you understand exactly what's going on, as opposed to looking at these older financials or these projected budget figures.
Exactly. Yes. Essentially, when we review all the documents initially, you're naturally left with some questions. Not every attorney submits a questionnaire to management, which is worth mentioning because it is a very important piece of that puzzle, like you mentioned. There is how many questions? We have a copy of your standard questionnaire here today, and we'll go through a couple of the key, what I think are like the most important. But 36 questions here that are critical to truly understanding the building that you're going to be buying in. And just that fact alone, that not everyone is doing a questionnaire.
So just to interject and add to that, the reason why some attorneys might shy away from submitting a full questionnaire is because usually the management company might charge a questionnaire fee. And I've seen fees as low as $50 and all the way up to $1,000. So that could be, something to take into consideration, especially if the budget of the clients is relatively tight. And in addition to that, some management companies will say that they need up to seven to 10 business days just to complete that questionnaire. Right. So you're looking at a 2-week delay.
Right.
And time kills deals. So you want to try to get everything done as efficiently as possible while also being effective.
Yeah, keeping the needs of the buyer, assuming in this specific dynamic that we're talking about, you're representing the buyer. So keeping the needs of the buyer in mind and asking them, right, what call they want to make when it comes to exorbitant questionnaire completion fees from management and long turnaround times. Very often our clients will tell us to proceed without getting the questionnaire back. So they do tell us that, but that is your choice, right? This is a choice that you're making, and at least you had the option. At least you had the choice.
Absolutely. And just to clarify, the reason why I'm referring to purchasers is because typically sellers are not, there's no need for them to conduct due diligence because they're just selling their property. And as far as buyers go, I've seen buyers waive due diligence. I've seen them sign and send a wire the same day that I've been retained. So I literally didn't do any due diligence. Right. It's at the end of the day, it's completely up to the clients. They're free to decide whether or not they want to proceed with the due diligence review. But typically, if they do waive it, it's because they're already familiar with the property. Perhaps they've rented in the building or they already own a unit. So they might be more inclined to waive the due diligence review. Whereas a first-time home buyer who has no idea what they're getting into wants as much information as possible. And as far as the delays go, sometimes there's extreme urgency because there's several other offers on the table and you just went through a bidding war. But other times you're the only offer that the sellers received, so there's not so much urgency.
Correct. Absolutely. Like you said, I love how you say pieces of a puzzle. We need to do what makes sense, give the client choice, figure out what the right approach is, and then act accordingly. But at least you know that your agent and your attorney have you in mind as the most important thing, and that you're going to get the absolute most thorough review possible.
One important thing to note is the fact that when it comes to these real estate transactions, it's really a matter of teamwork between the broker or the agent, the attorney, the managing agent, the transfer agent. There's a lot of moving pieces to the puzzle. And obviously, if the clients are looking to get financing, you have a lender that's involved, you have the bank attorney that's involved. So everyone really needs to work together to get to the closing table. And at the end of the day, that's where everyone wants to be, at the closing table to complete the transaction.
Right. Like you say, bad due diligence or things that are missed cost you money. Right? So these things that are overlooked that could potentially be problematic can cost you an exorbitant amount of money. So, for example, financials. What is the biggest, most important thing that you're usually looking for in financials? Is it the reserve fund? Is it something different?
So of course, there are a lot of different factors, but the main factors to take into consideration is what the balances are in their cash and reserves accounts, because you want to know how much money they have. You also want to see if they've been operating with positive cash flow or if they regularly have deficits. And the idea is that you are trying to take the information that you have and extrapolate on that information to try to predict what may or may not happen in the future after the transaction's been completed and your clients are now the new owners. So obviously you can't predict the future, but you gather as much information as possible to try to extrapolate on what you have to do your best to predict the future.
Right. Do you have a guideline or general ballpark rule of thumb of how much money you like to see in a reserve fund for a 100 unit building, for example?
Some people operate with rule of thumb figures, and they might say you need X amount of thousands of dollars per unit, or they might say that it depends on the type of the property, because there obviously are a lot of different types of condo buildings and co-op buildings. Some of them, it could be just a 4-unit property with no retail, no commercial, and it could be self-managed. So if it's a self-managed smaller property, obviously you're not going to expect them to have as much funds, or they might not even do such a great job at managing the property.
Right.
If you're looking at a larger building, 100 plus units, and they have retail and they have a garage, there's a lot more to take into consideration. But overall, you just want to make sure that they're managing and operating the property in a manner that there aren't exorbitant increases in the maintenance or common charges, and they don't regularly have special assessments or capital assessments. They're just doing a good job with their budget and their funding. And a part of that also has to do with, what type of increases in their expenses there are, because obviously the last couple of years there's been a very high rate of inflation. Insurance prices have gone through the roof, and there's just a lot of factors that you have to take into consideration. So if you just sum it up to give one figure per unit, it doesn't really help you as much as if you look at the totality of the circumstances.
Understood. Okay. So what people should understand, in addition to the reserve fund and financials, is that these are Manhattan buildings where problems that arise can be very expensive to fix. And even if it's not a problem per se, even something as simple as local law 11, which is required on all brick buildings
above 6 stories.
Above 6 stories, exactly, to do mandatory facade maintenance work, and that is a multi-million-dollar project, right?
Depends on the size of the property, but potentially could be, yes.
Could be. So where does that money come from if the financials do not have padding to pay for it?
If they don't have enough funds in their cash, or typically in the reserves accounts, then they're forced to either increase the maintenance or common charges or have an assessment done.
Right. An assessment is a one-time or short-term charge that goes to unit owners in addition to their standard maintenance.
Hopefully, yes. But there are some properties that have ongoing assessments, and they have no idea when the assessment will end because they're still working on whatever repairs are necessary. Just this past week, I was working on a building that they have an ongoing assessment for the local law 11 facade repairs. And they had an unsafe marking from the Department of Buildings. So it took longer than expected. It costed more than they expected. They finally got rid of the unsafe marking, but now they still need to complete the repairs, and there's still scaffolding and a bridge that needs to come down. So the assessment is ongoing. They hope that it will be completed in the next few months, but there's no way to really predict that.
And it's an expensive assessment for each unit on average?
Basically, they're doubling the monthlies.
They're doubling their monthlies for an unknown amount of time. So this is the type of stuff that, of course, you want to find during due diligence, and only proper due diligence will uncover it. And of course, getting to the bottom of what's going on, as many details as possible. But the worse the financials are before the building even has something going on, is it foreshadows the gravity of what you might owe when the project happens.
Yeah, to expand on that, there are a few factors where I would say a building is in good financial standing. The first is if they have a healthy amount of funds in the cash and reserves accounts. The second is their history of increases in the maintenance or common charges, or their history of assessments. If they have anywhere from a 1 to 5% yearly increase, that's fair game. But more than 5% a year is a little alarming. And if they tend to have assessments that are either ongoing or multiple assessments, that's typically a bad sign.
Very interesting. And that information is only found in the questionnaire, right?
The questionnaire
history
will definitely help you determine that, but you could also look through the minutes from the board meetings and see what increases there have been in there. In addition, when I reach out to the managing agent for the due diligence materials, I also ask for any notices that have been sent to the unit owners. So they could potentially provide the notices regarding maintenance increases or assessments in the past.
Gotcha. In new development buildings, there are no financials yet because the building is brand new.
Projections only.
So you're taking a risk with new development, right? Because there is no fully built up reserve fund yet, and there is no track record to look at.
That is correct. Any investment involves risk. Obviously, a new development has its pros and cons. One of the cons is you don't have any history or any background really to base your projections off of. But typically with the new developments, they have the common charges or the estimated common charges within the Schedule A from the offering plan. And the only way that they can increase those is by filing an amendment to the offering plan. So you can go based off of what amendments have been filed and what increases there have been. But obviously it depends on how far along they are in the project. And also, once the sponsor has sold a certain amount of units or a certain percentage of units, then the board will take over and they could potentially, give some more insight on the financials.
Right. Very good point. And it's not common, but we have seen new development buildings have fundamental structural issues that are not uncovered until after people are living in the building. Maybe there's a persistent leak on one side of the building or elevators that go out, right?
Unfortunately, I have a very specific example of that I'm dealing with right now.
Really? So, and I've seen it too a couple of years ago, so I guess it's not so rare. But
not only that, but sometimes the sponsor will not be doing the best work, and there could be issues. For example, with the facade, we were just discussing local law 11 facade repairs. There could be issues with that. There could be water damage, water leaks. And then what could potentially happen is that once the board does take over control of the property, they could sue the sponsor or the developer because of the damage and the work that wasn't up to par. And that could go in the favor of the unit owners, or it could go against them. If the legal fees, when they're suing the sponsor, if they increase to a certain amount where it's no longer even worth them going after the sponsor, that's one thing. But most of the time, the sponsor and the board will reach a settlement where the sponsor will actually cover the cost of those repairs. And obviously, that's to the benefit of the unit owners.
Right. And only once the litigation is resolved, right, can you really have transactions happen in that building in the meantime?
That's the thing about litigation. It can be dragged out over the course of a very long period of time, and that can become costly because of the legal fees. And they say when it comes to litigation, it's really only the attorneys that are making out all right.
Yeah, it's difficult. I think definitely 100%. I mean, I don't want to get too in the weeds on new development, but there is a significant lack of due diligence that can be done on them. There are issues, I've mentioned them in previous episodes, that you really have no way of knowing are prevalent until after people move into the building. So you do understand you take that risk, but also on sponsor sales, you're getting a lot of money usually. If you can negotiate well on the back end, maybe it's such a good opportunity that you're willing to take a little bit of risk, right?
Yeah, everything is negotiable. And when a client is working with a great broker like yourself, They
Thank
could
you.
they could potentially get a lot of concessions or credits towards the purchase price, or even towards amenities that they would otherwise have to pay for. They could potentially get a certain amount of months or years of common charge credit, so they don't even have to worry about those monthlies for a certain amount of time. Again, everything is negotiable. Everything has its pros and cons. But when you work with a great team, a broker like yourself, an attorney like me, then that definitely helps, it helps find the best possible deal that you can get.
Definitely. So we'll talk about meeting minutes because I'm interested in knowing exactly what that entails. I think our audience would like to know, what do you mean when you say meeting minutes? What are you really doing? What are those exactly? And how are they reviewed? And then the most important pieces of information that you can find in those meeting minutes.
Okay, so the unit owners or the shareholders of the building will vote for other unit owners or shareholders to be a part of their board. It could be the board of managers or the board of directors, but basically those are the people that are elected to run the property. And the way that they do that is they then go ahead and hire a management company to manage and operate the property on their behalf. And it's worth noting that any unit owner or shareholder could potentially be a member of the board. And in addition to that, typically they'll be forced to sign a unit power of attorney, which allows the board to act on behalf of the unit owners or the shareholders. And the management company that's hired by the board, they must do whatever is in the best interest of the unit owners or the shareholders.
Interesting.
So you asked about the meeting minutes. The board will meet every so often. It could be every month. It could be just annual meetings. It could be quarterly meetings. It typically depends on the size of the property. Smaller properties don't meet as often. But whenever they have those meetings, they're transcribed into what's referred to as the minutes of the meetings. So as part of the due diligence, attorneys will request from the managing agent to review the minutes from those board meetings. And the idea is to get an inside perspective on how they're managing the property and what's being discussed internally.
Key. How far back, how many years back do you want to look when you're reading meeting minutes?
That depends on how often they're meeting and how detailed the minutes are. I've looked at minutes where they're meeting at least every month, and each meeting is very detailed and the minutes outline every single item that was discussed. And obviously that's a lot more helpful, so you don't really need to go too far back.
Right. The odds are that current stuff worth knowing has been mentioned in a recent meeting.
Right. But if they don't meet very often, you might want to go a few years back. I think the standard amount is about 2 years.
Okay. Good to know. And that makes sense to me, that mostly all the things that would likely affect you as the property purchaser moving forward will have been discussed or found out 2 years ago, things that still haven't been things that haven't been taken care of yet to this day.
To go back to today's big question, what would be the consequence of not conducting due diligence completely and correctly? And the short answer is it could potentially cost you a lot of money. Because the idea of completing the due diligence is to ensure that they're managing and operating the property in an acceptable manner, whereas you won't have to deal with major increases in maintenance or common charges. You won't have to deal with large amounts of capital assessments or special assessments. You're already familiar with how they've been managing and operating the property. And based off of that, you know that they have a good amount of funds in their accounts. Their increases in the maintenance or common charges are reasonable, typically 1% to 5%. They only have special assessments or capital assessments every so often, and it was unavoidable because something, was a surprise to everyone, and there was no way to predict it. But based off of their history, you do your best to try to predict what may or may not happen in the future.
Yeah. And an interesting example of this that I've shared before, but I feel like every episode we get a lot of new listeners, so I'll mention it again. But personally, this is my personal experience. When I bought my condo a decade ago, my attorney, I know, did not do proper due diligence. And this was a family referral, the attorney that I used. And I don't think that he was a specialist at all in Manhattan buildings. And I know for a fact, well, I don't want to say I know for a fact, but I know that questionnaire was not done with management and meeting minutes were not read. And right after I closed on my condo, the building announced a new fee, a 4-figure annual fee for anybody that was subletting their residence. So I had purchased a condo specifically with the intention of eventually subletting it. And that is something I would have wanted to know. I would have definitely wanted to know about that. And there was zero regard. Even later, I believe, once it was so soon after I closed on the property that we found this out, that I felt like it could have absolutely been preventable, something that I should have been told. And I brought it up to the attorney, and there was absolutely zero care given. It was terrible. And I always tell my clients this story, along with all of the other ways that transaction was a nightmare because of the attorney and his demeanor. He screamed at me when I called him on his cell phone, because I was not allowed to call him on his cell phone. I was only allowed to call him on his office line. And I made a mistake, because sometimes when you have someone's number saved, you might hit dial and not know which number is being selected. And he accused me of lying when I said that that's what happened. And I obviously have no reason to lie. So it was so rude.
That's the main problem with not hiring the right attorney, is that they don't have enough experience with New York City condos or co-ops to know what to look out for.
Yes.
And although you might be saving money on the retainer fee because they're going to charge you less, they're going to do you a favor, in the end, at the end of the transaction, it's probably going to end up costing you more money.
More money. And when they are doing you a favor, or when they're like an easy referral, I feel like they're not really putting you at a pinnacle value in their desk full of work. And you're getting the level of work that is a favor level of work.
You get what you pay for.
You get what you pay for. And that's what happened in my situation. And I did not take the recommendation for attorney from my broker when I was buying. I thought that, I thought that I didn't really trust the recommendation, or I thought that maybe the broker, my buyer's broker, just wanted to use someone that would help the deal get pushed along, and that they wouldn't really be thorough, which now only after being in the industry do I know that you're getting a absolute professional when they're referred by an agent, because the person is in the business and they have exchanges with hundreds of attorneys a year, and they are only referring the absolute cream of the crop to their clients. And the attorney also doesn't want to mess up that relationship with that broker, because if your deal blows up or you have an unhappy customer, they will never send you business again. So you get much better service when you are using a referral, and there is absolutely nothing in the background going on that you should be suspicious about. But even just the way we work together, our clients never have that thought. And you are a licensed professional. You would never, skimp on your due diligence to push a deal along just because you're working on one of my deals.
Yeah, that's very accurate. And typically the attorneys who charge less, it's because they're not going to give as much attention to your transaction. Mm-hmm. And the reason why the legal profession is typically referred to as a practice is because the only way to get better at this profession is through experience. The more deals you do, the more practice that you have, the better of an attorney that you will be. So these attorneys who don't handle a lot of real estate transactions, they don't have that practice or that experience, and they might be charging less because they're offering you less.
Yeah, 100%. And people think, oh, it's easy. It's just contract review, which we're not even mentioning in this episode because we don't have the time for it. But that's a whole other story. It's a little bit more straightforward than analyzing the documents associated with these buildings, which is why we're focusing on it. But people don't know the value. They do not know everything that you're doing in these buildings. And that's, yeah, exactly like you said, the biggest concern that I have for my clients.
I've had clients who are buying a $5 million condo unit, and they're bargaining with me about my very reasonable legal fee. Like, yes, you can pay less to a different attorney, but chances are you're not going to get the best service. And with a $5 million piece of property, you're selling yourself short by hiring an attorney just because they charge a lower retainer fee.
Absolutely. It is the one thing that you don't want to choose based on fee alone. Truly.
And it's a very small figure compared to the purchase price.
Right. And on the other hand, there are also attorneys that do, courtroom work or litigators that charge an arm and a leg for these real estate transactions. You could pay 10, 15 grand for a real estate transaction and also not get good quality specialized real estate attorney due diligence level work.
Absolutely.
The other side of it too. So don't think that just because your attorney is a litigator or is very high powered, they absolutely must have a specialized Manhattan and Brooklyn branch of real estate attorney work, and you need to be using someone in that department for this. So I feel like we beat that to death, but I think it is just so important that I'm okay with doing that. We would like to talk about the other component of due diligence. You mentioned offering plan. What's really in that document? It is so long. I've never read one cover to cover. I'm sure you have, but what are we looking for in that document?
The offering plan is a document that a sponsor or a developer of a new project is required to file with the Attorney General's office. That offering plan makes it public knowledge, all of the minute specific details of the project from A to Z. It's from a description of the land itself to the finished product, including every detail, even what appliances are being used, what type of finishes they're using. It'll include the floor plans, and then obviously all of the other general information like their projected financials. It'll have the purchase agreement. It'll have the unit power of attorney. Have the bylaws, the rules and regulations. It just has every single detail that is required to be filed with the Attorney General's office. And those offering plans are typically only good for a certain amount of time. Could be, I usually see it for 12 months. And when that 12-month expires, they're required to file amendments to the offering plan. And as I mentioned before, if there are any changes to the offering plan, they would have to file amendments. Typically what that might be is if they decided to hire a new law office to handle their transactions, if they decided to change the pricing of the units, if they've gotten an update on the property taxes, because initially the property is taxed as a whole, but eventually they get the taxes assessed to each individual unit. Mm-hmm. So the offering plan is the initial plan that the sponsor developer has to build this project. And then the amendments are the updates to that plan.
So I could see, let's say a building was done 100 years ago. How relevant is that offering plan and amendments anymore, really? I'm sure the taxes for each unit have changed so many times year over year. There's a whole new renovation in the apartment that's unique to every different unit owner.
At a certain point in time, the offering plan becomes a moot document, whereas everything is outdated.
Okay.
And reviewing it doesn't really help you because there's been changes made to every aspect of that plan.
Right. So why do we always need it for every deal? Why do we request it?
Just to cover all of our bases.
Okay.
As we mentioned, it's a large puzzle and you want to try to have every piece of that puzzle just, to ensure that you're not missing anything.
Got it. Okay. Questionnaire, management questionnaire. Can we talk about that? Because the level of detail in your questionnaire is incredible, and our listeners should know the types of things that you're asking these buildings so that they can understand what questions are being missed if this questionnaire does not go in to management, or if their attorney is not finding through other ways of answering these questions. I have a copy of your questionnaire in front of me, and I circled some of the questions that I think are so critical. And of course, if we, skip over anything that you feel is worth mentioning, we'll discuss it.
Sounds good.
Yeah. So what I think is important that we already talked about, we discuss in this management questionnaire, you ask about assessments, you ask about the monthly maintenance increases over time, you ask about if there are any upcoming assessments or maintenance increases planned, right? Self-explanatory in terms of why you would want to know that.
Definitely. We're also asking for the cash and reserves balances. We're asking if there are any upcoming or potential improvements that could lead to assessments. We're asking if there are any upcoming projects, could be Local Law 11. We're asking if there's any ongoing or potential litigation, any threatened or any claims that could potentially affect the property or the unit owners. We're asking as many questions as possible, whereas without this questionnaire, it would be very difficult to find these answers.
Absolutely. For example, a question that I like is, are there any damages or repairs to the property or the unit? Meaning, this is where you might find a complaint that was submitted for a water leak in the residence, right? This is where you would see if there was a structural issue. This is where you would see if another resident in the building caused damage to your unit, right?
Yes. And in addition to that, there's a question in there asking about the lot line windows. So there's a question asking about if there's anything that could potentially affect the property or the unit. And the typical response, or what you're really looking for, is something that a lot of buildings do have, which is lot line windows. And that means that an adjacent property could potentially be built to a level that covers your unit's windows. So you want to address the potential for anything that could obstruct the view of that unit.
Right. Very important. Very important. And I like how the question's phrased too, because you're like, anything that could affect the property or the unit in the near future. You provide the examples that you're looking for. But I do feel like it does require management to disclose anything that they are aware of. And then in addition to that, a lot of times we'll be curious. For example, we're looking to buy a property and we'll see across the street in our line of sight from the apartment in the view, it looks like there's construction being done, or like a building across the street is having work done, and we want to know how tall that building is going to go. What resources are you using to do your best to figure out about the surrounding area and if the view is in jeopardy?
If the managing agent can't provide additional information, you have to get a bit creative. You can try going on the Department of Buildings website, but there are some circumstances where it might not be public information, and you might need an architect or an engineer to try and get the inside scoop for you somehow.
You need to see what was filed for that. You need to know the address of the property in question, and you need to look into what was filed for it, right?
That's one avenue, but an architect or an engineer might have other avenues that you as a broker or me as an attorney are not aware of.
And this is something that you do. You ask for this type of information.
If it's a major concern of the client, we'll dig deeper.
Especially when you're paying more for a certain view.
Definitely.
When you're paying more for a certain view, you do want to make sure that you understand if there are risks in the general vicinity, in the immediate vicinity. And we still can never really guarantee. I think that that's still always important for buyers to understand, is that if a developer really wants to go up across the street from you and they really want to go high, they probably will find a way to buy the right to do it from the city somehow.
Yeah, you could buy air rights.
Exactly. They'll see where they can get air rights. They'll give the city a park, and they'll find a way to get the air rights to go higher. So you could do all the due diligence in the world, and sometimes you still can run into this problem.
To add to what you just mentioned, it's good to note that the contract of sale or the purchase agreement doesn't have the management as a party to this agreement. The contract is between the buyer and the seller. So the questionnaire where you're requesting all of this information from the managing agent, they're actually not a party to your contract. So if you are misinformed or they knowingly lie to you, it's hard to address that within the contract. You could potentially sue the managing agent, but obviously that would get dragged out, and you would still need to abide by the terms of your contract between you and the other party. So yes, the questionnaire is a great way to try to get as much information as possible. But if the management company is not being helpful or is knowingly lying to you, there's not a lot you can do at that point in time.
I had a situation where in New Jersey, actually, where I was working with an agent partner of mine out there who's used to the Jersey market, and there was a real estate attorney in Jersey that was being used for the deal, and this was my friend that was buying in a new building. And in New Jersey, as well as many states, which is why a lot of our buyers here in New York think due diligence is not important, because due diligence doesn't happen there. There is no due diligence. Very little due diligence is done in New Jersey.
Well, you could say the same thing about Long Island. If you're buying a single family home in Long Island, you're not dealing with a management company or monthlies or anything like that.
Exactly. And that's where I believe it comes from, because it's only recently, I don't want to say it's only recently, but there's a smaller percentage of the overall housing inventory in New Jersey is a building that would be affected by the things we're talking about. So these attorneys are not, due diligence is not part of their process. And as soon as my friend closed on his apartment, he found out that the apartment was an absolute mess. Like, the building was about to go into litigation because the developer cut corners and didn't insulate any of their units. They were not done to code. And everybody could hear everyone's conversation in the building. The walls were like paper thin, and there was not an ounce of insulation in them. So after he moved in, he actually had to open up all his walls and insulate all his walls himself. And it was a very significant expense for him. And there was nothing that he was able to do about it because it wasn't uncovered during due diligence. And it's one of the things I still feel so terrible about that, because he's my friend and he had all the best resources. But in that instance, it's a perfect example of an attorney that is probably used to, it's just their standard practice there. It doesn't matter what they're used to and what can happen when those questions aren't asked.
I'm not so familiar with New Jersey transactions, but to go back to Long Island, if you're buying a single family home, instead of doing the due diligence prior to execution of the contract, what we do is we order a title report. But that's only after getting a fully executed contract. And the title report helps you get information about the seller and the property. And if there are any open issues, the seller is required to clear them prior to closing. So it's
another stopgap.
With New York City, you're doing that due diligence prior to contract execution.
Yeah.
In Long Island, you're doing that after you've already signed the contract, given your deposit,
Committed.
and
Yeah.
received a fully executed contract that's already binding.
So you have no negotiation leverage at that
Well,
point.
negotiation leverage, not so much, but the contract does provide protections, whereas title must be clean in order for you to close.
Correct. That makes sense. That's an interesting point. I think a lot of people are used to the way it works in other areas that aren't like central New York City areas, and it's very different here.
New York as a state is a different animal. And then when you look at apartment buildings, condos, and co-ops, it's a whole different ballgame.
Yup, exactly. You ask a question in this questionnaire about subletting rules, but let's save that. We'll briefly go over the importance of understanding the house rules and the bylaws when we're done with the questionnaire conversation. So I'm going to table that one for now. But you do ask about how many of the apartments in the building are owned by the sponsor still, are subletted, or versus owner occupied. Why is that such an important question?
Mainly for financing purposes, because certain lenders have different requirements or different limitations. So it's really to help with that aspect. And also it could affect the unit owners, because if the sponsor still owns a majority of the units and the sponsor is in default, that's, a large chunk of units. You're not just worried about one or two unit owners. You're worried about a sponsor that owns multiple units.
Right.
And if they're in default or they're not paying their monthlies, it affects everyone else more so than it would if it was just one unit.
Interesting. And do they have like decision-making share like over the board too at that point if they own a majority?
It depends on what the offering plan provides, and it depends on what phase they're at, whether or not the board is in control at that point in time, whether or not the sponsor has seats on the board. It depends on where they're at.
So you ask about litigation, you ask about the status of local law 11 work, which is very costly, obviously so important. And you ask about if there's pet infestation problems that have been reported in the building, which is also so critically important, because that's something that every New Yorker is scared of, is that are they going to move in and is there going to be roaches or rats that are an issue?
Well, the worst is bed bugs.
Oh my gosh. Yeah.
And then I've also had a client who, for whatever reason, she was super sensitive to mold. So
right.
You also want to find out if there's a history of mold.
Yep, only can be found through due diligence. There's no other document that will get you there. Very quickly, I know we've been recording for a while now in the interest of everyone's time. Bylaws, house rules. Very important to know certain policies. Do you have any examples? Subletting policy, general things to keep in mind there?
Well, as far as the bylaws go, that's basically a guideline for the board on how they should be operating. And then obviously the house rules is more for the unit owners. And you just want to make sure that your clients are comfortable with that property's house rules, with whatever requirements that they do have. It might include a minimum of homeowners insurance. Certain buildings have a lot higher requirements than others. And you also just want to make sure, like, obviously, if the client has pets, you want to make sure that the building's okay with pets. If the client plans to host dinner parties, you want to make sure that's not a problem. It just depends on what your client is concerned about.
Yes, the house rules can be an indicator of what life in the building is like to a certain extent. Of course, take it with a grain of salt and do more research when you need to, but I'm sure you've seen some crazy house rules, and in co-ops especially, they can be really nuts.
Co-ops can do whatever they want. They're a private entity. They can do anything.
They can do anything. The craziest I've seen, I was working on a building that was the most insane regime I had ever seen. Very politically charged board, very, very highly dramatic, and the board's rules specifically said that if you have a child in the apartment, the child cannot laugh, I swear I saw this in house rules. The child cannot laugh. The child cannot run.
How are you going to avoid that?
You
Basically,
can't.
they're telling you if you have children, don't live here.
They don't want it.
Yeah.
They really don't want it. And how crazy is that though? But that's writing on the wall. Like if you have a bill where you're seeing stuff like that, that is so crazy. It almost feels like someone on that board like hates children or something like that. Like you can kind of see problems from afar.
Yeah, that's a good way to look at
when
it.
house rules are crazy, right?
For sure.
Yeah, absolutely. Anything else that you want to leave our audience with as a final thought or most important takeaway?
I'd just like to reiterate the fact that for most people, this real estate purchase is one of the largest investments that they're going to make. And although it might be your home, you have to treat it as an investment because there are a lot of financial consequences. And it's not just where you plan on living or raising your family. It's also how your financial situation will lead.
Absolutely. I completely agree with you. I appreciate your time. Thank you for all the knowledge that you brought us today. This was incredible.
Thank you for having me.
Where can our audience find you? How should they reach you?
The best way to reach me is on my website. You can just search for Movtady Law Office and you'll find Jonathan Movtady.
Excellent. And Jonathan's information will be linked in this episode description. So it will be very easily accessible to you. I highly encourage that you call Johnny.
And just to add to that, I know that you have a big following on social media, and I like to use Instagram. So if you would like to find me on Instagram,
What's your handle?
Johnny MOV, JONNYMOV.
And then you get more than the cool outfit if you go check that out. You're like out with your pit bull. Yeah, your Instagram's wild.
I'm not your typical attorney. Let's put it that way.
Typical attorney, but it's a good thing.
Thank you.
Thank you, Johnny, and thank you guys for being here again. And stay tuned for the next one.